Boykin v. Alabama, Supreme Court, 1969. Justice Douglas delivered the opinion of the court. In the spring of 1966, within the period of a fortnight, a series of armed robberies occurred in Mobile, Alabama. A local grand jury returned 5 indictments against petitioner, a 27-year-old Negro, for common law robbery, an offense punishable in Alabama by death. Before the matter came to trial, the court determined that petitioner was indigent and appointed counsel to represent him. 3 days later, at his arraignment, petitioner pleaded guilty to all 5 indictments. So far as the record shows, the judge asked no questions of petitioner concerning his plea, and the petitioner did not address the court. A plea of guilty is more than a confession which admits that the accused did various acts. It is itself a conviction. Nothing remains but to give judgment and determine punishment. Admissibility of a confession must be based on a reliable determination on the voluntariness issue, which satisfies the constitutional rights of the defendant. The requirement that the prosecution spread on the record the prerequisites of a valid waiver is no constitutional innovation. Presuming waiver from a silent record is impermissible. The record must show, or there must be an allegation and evidence which show, that the accused was offered counsel, but intelligently and understandingly rejected the offer. Anything less is not a waiver. We think that the same standard must be applied to determining whether a guilty plea is voluntarily made. For, as we have said, a plea of guilty is more than an admission of conduct. It is a conviction. Ignorance, incomprehension, coercion, terror, inducements, subtle or blatant threats might be a perfect cover-up of unconstitutionality. The question of an effective waiver of a federal constitutional right in a proceeding is, of course, governed by federal standards. Several federal constitutional rights are involved in a waiver that takes place when the plea of guilty is entered in a state criminal trial. First, it is the privilege against compulsory self-incrimination guaranteed by the Fifth Amendment and applicable to the states by reason of the 14th. Second, the right to a trial by jury. Third, it is the right to confront one's accusers. We cannot presume a waiver of these 3 important federal rights from a silent record. What is at stake for an accused facing death or imprisonment demands the utmost solicitude of which courts are capable in canvassing the matter of the accused to make sure he has a full understanding of what the plea connotes and of its consequence. When the judge discharges that function, he leaves a record adequate for any review that may be sought later and forestalls the spin-off of collateral proceedings that seek to probe murky memories. Note: because the trial court failed to obtain from the defendant a full waiver of his rights, his conviction was overturned.